Good evening. Thank you for joining me. This is a class recording of April 2024, Part 2, Conveyancing. Today, 19th October 2024, I'm going to deal with the question 4, 5, and 6. Yesterday, I dealt with question 1, 2, and 3, and they were participants. But today, they have delayed to join. But they may join me in due course. So, conveyancing is one of the difficult subject. Let me start with prayers. Father, I come before you. I thank you for this day. Thank you, God, for giving me yet an opportunity to conduct this recording. I pray, God, for the person who is going to see this recording after it has been uploaded to YouTube channel, to be able, God, to help him or her to prepare for the exams. Help me get subscribers and purchases on the Buy Exam Preparation website. Let me be able, God, to dispense knowledge and wisdom as I tackle these questions. I pray all this believing in Jesus Christ, my Lord and Savior. So, conveyancing is one of the most difficult subjects. The people who this is one of the subject people finish doing the receipts together with commercial. So the most of the people who I know are doing receipts are doing conveyancing. So it's one of the most difficult subject, but it's doable if you are able to follow what I will say here and what I've said in the last videos. So to pass this subject, you need first of all to understand the Land Act, its subsidiary registrations, Land Registration Act and its subsidiary registrations, and General Regulation 2017, which have the processes and the forms. You also need to understand very well the Law Society of Kenya Condition of Sale 2015. I forgot to mention that yesterday. So if you read clearly those regulations and the acts, you are going to tackle all the most of the question. But of course, there are specific topics which you don't rely on the Land Act, their legislation, and its regulations, like community land. That is specific to Community Land Act and its regulations. But you also need to have understood Land Legislation Act and the Land Act. Also, section of properties is very specific. Uh, uh, yeah. Then a topic like controlled tenancies has its own act. Yeah. Then other conventional sale agreements. Yeah. Like fractional, that topic in the course outline. Other conventional sale, which does not fall like fractional sale. So that is what you need to understand, and you shall be good to go. You also need to visit the Sasa YouTube channel on the processes because everything is being done under the SASA these days, the National Land Information System. And you also need to, of course, visit the Ministry of Lands. It has a lot of information. More importantly, you need also to look at the past papers. The the function of past papers is to help you to if a question that welcome Kate.
Thank you, Mwalimu.
Yeah, so I was just doing the introduction,
Yes, yes. Sorry
and
for joining late.
no, you are on time.
Okay, thank
So I was saying, I was just doing the introduction on how to pass the conveyancing,
Yes.
from my experience, from
Mm-hmm.
many years of experience, from the time I was in Kenya School of Law, doing research, teaching online and physically. So if you read the Land Act and its regulation, Land Registration Act and its regulation, the most important is that General Regulation 2017 with a
Mm-hmm.
tooth comb,
Mm-hmm.
understand those sections very well. You be good to go,
Okay. So the Land Registration Act and the one with the regulations.
Yes, the Land Act and its regulations.
Mm-hmm. So we have the Land Act and we have the Land Registration Act, and then we have the 2017 one that is the regulations.
Uh-huh.
So the three or
Yeah, I'm saying
mm-hmm.
if you look at the Land Act under Kenya Law Report website,
Yes.
you see its subsidiary registrations,
Uh-huh.
which are the land allocation of public land, which deals with the allocation of public land,
Yes.
the land assessment and just compensation rules, which deals with compulsory
The
acquisition,
yes.
the land conversion of land rules, which deal with
Conversion.
conversions of land, especially from
Uh-huh.
yeah, from public to yeah, unaona. Then
Yeah.
the land extension and renewal of licenses rules,
Uh-huh.
which deals with extension and
Re
renewal
and renewals, yes.
of leases, which you must involve the National Land Commission, unaona.
Yeah.
Then the land regulations.
Yes.
Then the subsidiary registration under the Land Registration Act, Land Registration Act,
Uh-huh.
are, the most important here, they are registration, the land registration unit order,
Mm-hmm.
and the RAD General Regulation 2017. Those are the most important.
Yes.
So this thing you must use this thing. Many questions revolve around here.
Mm-hmm.
Let me admit someone. Welcome, Susan. You can hear me? Okay. So you come again. So those are the nini, the nini, what you need to deal with.
Okay.
Of course, I said there are those There are specific topics in conveyancing which largely they don't touch on land registration act and its regulations, like the section of properties, no,
Yes.
and community land.
Uh-huh.
Of course, you read together with those acts, and also the controlled tenancies. That act called the Landed and Tenant Shops. Do what? Eh?
Mm, mm, mm.
You know that one, eh?
The one for tenancy.
Controlled tenancies, where
Okay.
yeah, controlled tenancies is a topic, eh?
Yes.
Then change of user.
Mm-hmm.
Change of user does not depend on land act, land registration, and their subsidiary registration. That one is that one that one depends on the Physical Planning Act and its regulations, eh?
Okay.
So that is it, eh?
Yes, mwalimu.
So these are the areas someone needs to nini. And of course I've said also that the function of the past papers, eh?
Uh-huh.
And this everything to do look at the past papers and the recording is that in an exam you find three to six questions are repeated directly or indirectly, unaona.
Mm-hmm.
So you have a head start, eh?
Yes.
Especially for the question that have been tested, and yesterday you looked at them, some of them, eh?
Mm-hmm.
So it is very, very important to look at the past papers diligently, eh?
Yes.
Yes, you have a head start, and of course, someone in KSL who scored good projects and orals, eh?
Mm-hmm.
Also have a head start because you are not looking for 30 out of 60.
Yeah.
You are looking at less than that. You know me,
Uh-huh.
I had this called commercial, eh?
Mm-hmm.
I got 29 out of 60 in the main exam, eh?
Oh, okay.
So I failed, but because I had good orals and project, eh?
Mm-hmm.
A project 13 and orals 12, that is 25 plus 29, 54. Unaona?
Mm.
So projects and orals usually help. Unaona?
Kabisa.
They usually help. They usually help. And project are research. So let's go to the question of the day.
Mm-hmm.
So you can see the paper.
I can't see it shared, but I have the paper.
Helen, welcome. Eh?
Thank you. Thank you.
Can you see the paper?
No, it
Helen?
was there, but it was there, but it's not there now.
Okay, let me project 1 minute. And now?
It's okay.
You can see it, eh?
Yes, yes.
Yeah, you look at your audio, eh? I now you can see I can hear you are clear, eh? So let me
Yes,
read the
yes, yes. I
question.
changed the gadget.
Okay, so let me read the question. Macau Bora Limited is a real estate company that has a reputation. This is question for April 2024. Macau Bora Limited is a real estate company that has a reputation of delivering residential units to its customers. Last year, it took a loan of 10 million shillings and acquired Kiambu Block 193/539, measuring approximately 10.34 acres or thereabout. They intend to construct residential apartment blocks on the land. Having taken a loan to purchase the land, they are averse to the taking of another loan to construct the apartment blocks. Advise Macabora on the options available to them to finance the contemplated project and bring it to fruition. So, Kate, I want you to interpret the question. I don't want you to give I don't want you to give the answer first.
Not the answer. Okay, okay.
Yes, yes.
So so this is Macabora, a real estate company, took a loan to buy property with the intention to build apartment blocks. So since they took a loan to purchase the land, they are seeking for other sources of financing to be able to put up the property. So what options would be available for them to finance the residential apartment blocks? Yes, that's how I understand the question.
Yes, so you have understood where, but there's something, there's something called the cruise of the question. There's something you have missed.
Okay.
Helen, can you say what she have missed?
I'm not sure about what she has missed. I don't know. But all I'm seeing is that Macabora is looking to personally finance the construction. They are not willing to take up another loan for purposes of the project that they want to undertake.
Yes, so they have already taken 10 million to acquire the 10.34 acres. So, but now they don't want to take another loan to build the houses.
Yeah.
So what are the options available for them to finance the contemplated project without taking another loan? So that is a correct interpretation. What do you think, Kate?
That they don't want to take another loan. Okay.
Yes.
As to the options, when I was looking at this question, the only option I saw is because they already do residential units, they've done it successfully. I would tell them an option for doing off-plan and selling it off-plan and having the financing to be done by the intended customers.
Yes.
I think I tried to think about any other option. I assumed because they already took a loan to buy the land, they don't have personal funds, like company funds, that they can use. So that was the only option that I saw.
So that is the correct answer. In fact, the question is very specific on it is on the option. So it's not options, it is option. So it is one.
Okay.
So it is off plan. So to get 5 marks. So I told you every time you are answering a conveyance question, by default you are being told to be asked. You are being asked about the process.
Yes.
So, but now the process you are going to coach it in a way that is now going to bring is providing Macabora Limited on the financing. So that is the answer.
Yes. So to get 5 marks, like how do you break it down? With the exception of saying, like get the architectural drawings, get the drawings,
So
get the
I
relevant
want to
brochures.
I want to give you the answer.
Okay.
So you start by explaining, of course, what are off plans.
Okay.
Off plan properties refer to real estate that is available for purchase before construction is complete. So buyers are essentially purchasing the architectural plans and a promise of what the property will become once finished.
Mm-hmm.
Yeah. So you explain what is an off plan.
Mm-hmm.
Then for them to now to realize that, remember you are the question is asking you this Macaobora, the financing.
Mm-hmm.
Now you talk about the process. Of course, it will be advertisement.
Yes.
Macaobora are going to advertise for off plans for potential buyers or purchasers.
Mm-hmm.
Yeah, and they are going to of course to talk about the after what how the residential houses are going to look after they are completed, the price, unaona,
Mm-hmm.
the mode of payment, unaona.
Mm-hmm.
So a purchaser or a buyer who is interested is going to sign a purchase agreement with Macaobora Limited and make the initial deposit.
Mm-hmm.
Of course, it will be subject to the agreement. So as construction progresses, the investors or the buyers, the purchasers, you can use any term interchangeably. Investors, buyers, purchasers may make regular payments according to the agreed payment schedule. So they can be able to make maybe after every 3 months. They pay something. So this is the money which this Macaobora is going to use to build. The initial deposit and the regular payments made by the investors. Yeah, and you earn your marks.
Okay. Thanks for that. So beyond that, because I've written down the points, there's no expectation of maybe disclosing the documents that will be required.
You see,
Mm-hmm.
in an exam,
Mm.
you tailor your answer to the question.
Mm.
The question is very specific. Macaobora on the option available for them to finance. Unaona?
Mm.
Another question may ask you about the documents required in an off plan. Unaona?
Okay, understood.
So now there you talk about the documents.
Okay.
So in this situation, you did not need to talk about the documents.
Yes, yes.
And And offline question, it has been asked again, eh? Question 2, October 2022, they asked you, you look at the Q&A. They were asking now about the disadvantage to the buyer. Unaona? It has been tailored. They were asking the disadvantage of off-plan to the buyer, to the buyer. Unaona? So you answer the question according to how you have been asked. Unaona? In another question, they can be asked you about the documents. So go and study about the documents. Eh?
Okay.
Yes. So that's how you answer. You know, that's how, this is why students fail, eh? Because now you see, you have the knowledge of off-plan, eh? But now you must be able to apply it to the question, eh? Or any other topic or subject. Unaona? At any given time, you must tailor what you have learned and apply it to the question. Unaona? Yeah, that's how you get your marks. So are we together, Helen?
Yes. Yes.
So we go to the next question. Ben owns 2 plots, A, B, each which measures 50 and 10 meters. Block B is adjacent to the Muru Road. Block A butts Block B on the eastern side towards the road. Block A adjoins Daniel plot on the west, Mike's plot on the north, and borders Yvonne plot on the south. Ben has agreed to sell Ian, and Ian has agreed to buy Block A. Advise Ian on his rights, 3 marks. And I told you, marks guide you how you should write. If it is 5 marks, those are 5 points. If it is 3 marks, those are 3 points. And you break them down. You earn maximally. So Helen, how do you interpret this question?
With how I'm interpreting it, I've tried drawing it, but I don't think I'm getting it right. But what I can say that these are several parcels of land. Some of them share boundaries, including the one that has been sold to Ian. And I believe that there has to be trouble with access by Ian to this particular land. So what we're trying to find out is how Ian can, if access is the problem, how can Ian gain access to his land if the other adjacent parcels are interfering with his with ease of entry? Yes.
So that is very correct interpretation. You start by drawing a sketch. Eh? So if you could have been doing if you are doing physical classes, I could have shown you the sketch I do. Eh? So you draw a sketch first. Then secondly, you now Ian plot A is in between all these plots. Eh? Mike, Daniel, Yvonne, unaona?
Okay.
And plot B. So he needs to access, and also there is Remuru Road. So that is a correct interpretation. Now, this question is reading you to is asking you on what? In conveyancing.
I think that would be overriding interests. Right of way is what I'm seeing.
Yes. Right of, sorry?
Overriding interest, and the specific overriding interest would be the right of way that Ian would need to have over his neighbors for him to get access to perhaps the Limuru Road.
Yes, is right of way. But in this scenario, this is asking you on you understanding on dominant and subservient land, easement.
Yes.
Easement,
That so the actual right to be granted or for Ian to apply for is an easement. Yes.
Yes, an easement. You see, you have talked about overriding interest. Why are they called overriding interest?
Their interest that sort of supersede your overall interest on your property as the proprietor or the user of the land. Yeah.
I want you to look at your let's can you look at your section 28 of the Land Registration Act? You have it.
Okay. Yes. Let me just delete.
I can project.
Yeah, I yes, you can project it. I've found it. Yes, overriding interests. Unless the contrary is expressed in the register, all registered land shall be subject to the following overriding interests as may for the time being subsist and affect the same without their being noted. They are being noted on the register. Trust, including customary trust, rights of way, rights of water, and profit subsisting at the time of first registration, natural rights of light, air, water support, rights of compulsory acquisition, resumption, entry, search, and user compared by any other written law, charges for unpaid rates and other funds which, without reference to registration under this Act, are expressly declared by any written law to be a charge upon land, rights acquired or in process of being acquired by virtue of any written law relating to the limitation of actions or by prescription, electric supply lines, telegraph lines or poles, pipelines, aqueducts, canals, wells, and dams erected, constructed or laid in pursuance or by virtue of any power conferred by any written law, and any other rights provided under any written law. Yes, provided that the registrar may direct registration of any of the liabilities, rights, and interests herein before defined in such manner as the registrar deems necessary.
So, you know, why I'm telling you to you know, the reason why they are called overriding interest, they override they override a title deed. They need not to be noted on the registry. Unaona? For you for them to bind a buyer or unaona? For example, customary rights, if someone they had for example, if you remember in Kikuyu where some people grandfather the title deed is written under the father's name to hold in trust for the ancestral land in trust to other brothers and sisters, so that registration of that person, we can call it Kamau, although it's noted on the register his name, but he owns the rights over other people, so he cannot be able to sell. It's not his land. So I wanted you to understand the term overriding interest.
Yes.
They are called override because they override a title deed. They don't need to be noted on the land registry. Unaona?
Mm.
That's why they are called overriding. Unaona?
Yes.
Yes. So the correct wording here is easement, where someone has the right over another person's land.
Yes.
Dominant and subservient land. So the Land Act define easement. You need to know the definition of easement. Defined there. You can look at your Land Act.
Yes. So it says has the meaning prescribed to it in the Land Act.
Mhm.
Let me just pull up the Land Act.
Two on this easement means non-possessory interest in another's lands that allows the holder of the use of land to particular extent to require the prepare to undertake. So that is non-possessory interest in another.
Mhm.
You are there?
Yes.
So section 136 of the Land Act so that's why I'm telling you, if in these exams you must understand these acts very well. That is the secret of searching. In the part, unless context otherwise require, the land that benefits from any easement is called a dominant land. And the person whom an easement is created is called a subservient land. Subservient land. Land referred to as benefiting land. And in relation to subservient land, is referred to as burdening that land. So again, you are saying that the nation, you say that Ian is this land that will be bought by blockade, bought by Ian, agreed to sell, and Ian has agreed to buy. So it's the dominant land. And a servant. Yeah, you apply to with the question. So, yeah. So, application of this part. This section 137, this part shall apply to all is meant to make or come into force after the commencement. Section 1 shall not, unless stated specially otherwise, apply to easement, profits, restrictive agreement, or any other restriction on the use of land having effect in customary law only. Analogous rights means access order made under section 140. Nature of easement. Subject to any written law, the use of land, the rights capable of being created by an easement are any right to do something over, under, or upon the subservient land, any right that something should, any right to require the owner of subservient to do something over, under, or upon the land, any right to graze stock on the subservient land. The right capable of created by an easement do not include any right to take or carry anything from subservient land. So if you want to take something, a question I've asked you, someone wants to take something from the land that is not belong to him. You know, they're asking you about what, Helen? Kate?
You've asked. Please repeat the question.
I'm projecting section 138 of the Land Act.
Yes.
The right capable section 132. The right capable easement does not include any right to take away anything from subservient land. So if you want to take something from subservient land, what will be that question has been asked in the past if you have interacted with questions and answers?
I've seen something called profits. It's can I type it? Let me type it because I don't know how to pronounce it. Just give me a minute. I've seen something like that allows you to take something from the land.
Let me. You have that put there in the chat.
Yes.
Yeah. Sensi. Unaona?
Yes, I can see.
Yeah, you'll be licensed. You become a licensee. Unaona? You know, I'm helping you interpret this question when they come. Then there is we on the Land Act. Any right to exclusive possession of land. Who has an exclusive possession of land?
That would be the proprietor of the land.
The proprietor of the land or
the leasee.
Yes. What are the rights of a leasee?
Possession, exclusive possession, but it can be with or without consideration, depending on the kind of agreement that is there.
Yes, quite possession. You know that one of the requirements is quite possession, eh?
Yes.
Yes. So if the question that comes like that, unless an easement has been created for a specific period, which will terminate at a fixed date in future or happening, this is section 138.3, been created for a specific period of time, which will terminate at a fixed date in future or happening of specific event in future or some other person named in the grant. An easement burdens the subservient land and lands with the land for the same period at time as the land or lease held by the guarantor who created that easement. Subject to provision of this part, an easement shall be capable of existing only during the subsistence of the land or lease of which it was created. So you must understand on easement, you must understand section 136, 137, 138, and 139 very well to be able to understand, to be able to answer question on easement. So we go now back to a question. Advise Ian on the rights in the disclosed circumstances. Now you answer the question with the knowledge you have on easement. So, of course, you start by defining an easement, dominant, servient, and benefiting and burdening. So, advise Ian on the rights in the disclosed circumstances. What are his rights? Give you a trial, Kate.
In my view, his rights are rights of way, and he
Right
would
of
need
way,
to,
right of way. That is correct. Yeah. Right of way.
So advise Ian on his rights in the disclosed circumstances. So in the rights of way, it is what now Helen has put on the chart, profit apprendre, where he has a right to use, because it says the definition of what she has put on the chart means that the right to use the land, the soil, whatever it is that is there for his benefit, is that now he will have a right of way across the various properties that are next to where he's at, because he's landlocked, to exit, to access and to get out of his property. Yeah. And but yeah, I stand guided by you, Mwalimu.
So profit padre is a right to take from the land owned by another person, part of natural produce grown on that land, or part of the soil as rock composing of that land. So this one is where I said you need to be licensed by the subservient, by the
by the
burdening,
dominant.
by subservient.
Isn't the servient land, my understanding of the servient land, that will be Ian's land, and the dominant will be now his neighbors.
Is the other way.
Okay.
The servient is the one that is being burdened.
Understood.
And the dominant is the one that is benefiting.
Okay, understood.
So he needs to be licensed by the Nini. So profit padre does not apply. So one of the Nini is right of way.
Okay.
Right of way. So remember, an easement is non-possessory.
Yes.
Non-possessory. You don't possess something. So it's a right of way. Just right to pass there. Yeah. So is another right is he has a right to neighbors, to connect to the neighbors sewer line, electricity line, telephone line. Yeah. So you know how we do it. This is very practical.
Okay. Yeah.
Yeah.
So when basically access to utilities and
yes.
Road.
Yes.
Okay.
Yes. So that was the answer. Right of way, then right to access to utilities found in the subservient or burdened land belonging to other people. Unaona? So that was the answer.
Okay.
Of course, you start by talking about, you must talk about easement, what is an easement, benefiting and dominant as subservient, burdening and benefiting. Unaona, then you talk about the rights. Then you earn your 3 marks. So we go to the next question. Explain the instances in which the right B above would terminate. So another question, this question is asking you, how would be all the rights that we have identified in B, how would they terminate?
Could you rightly use when it is refused? The answers for when the easement can be refused or when it's terminated. So I think just top of my mind, if the easement was time bound on expiry of that time, if he ceases to own the land, he wouldn't. The rights of easement is not on him as a person; it's on the user of the land. So those are the two instances, like top of my head, if I was to think about it
Okay,
practically.
repeat again. You have the answer with you. Repeat it again.
So the first one, if the easement had a fixed time on the expiry of the time, and when Ian ceases to be the user or proprietor of the land, then he does lose access. Yeah, those are the two that come top of my mind.
Yes, you especially on the first one. It is correct. So if you look at section 138.3, yeah,
Yes.
which is I think, let me project. You know, conveyancing is you need to read and understand this land act and be able to interpret it in a question. Eh? So unless section 138.3, unless an easement has been created for a specific period of time, which will terminate at a fixed date in future. So your first answer is correct. Eh? So if it is an easement that is created for a specific time, expressly, it terminates on expiry of that time. Eh? That is number one. Or happening of a specific event in future. What are these specific events in future?
It could be anything, including that provision
It is
of
not
access
defined.
is, yes.
It is
It's
not defined.
time-based.
But,
yeah. It could be anything whereby if perhaps another access is provided that doesn't have Ian landlocked, then he may not need that easement across the servient land, across the servient land, if perhaps an area is opened up. That's an example of the specific event I would have in mind.
Yes. So that is a change of circumstances. Eh? So change of circumstances, significant changes that make easement no longer necessary for the dominant land. So yeah, that is it. Eh? So another specific event that can happen, it's not defined. Now this, I went for research and I came with this. Eh? So destruction of dominant land. Eh? So if dominant land is destroyed or ceases to exist, the easement terminates.
Yeah, makes sense. Because the rights attached to the land.
Yes. Merger. If the dominant and subservient eminent come under the same ownership, the easement will extinguish.
Fall away.
So if they become the same, the owner of the dominant and subservient, the easement will be extinguished because it's a right of another person's land. But now the owner is the owner of the both land. Eh?
Yeah.
So, yeah, consent of both parties. The easement can be terminated by both parties agree to end it. Court order. A court can terminate the easement if it deems appropriate based on the circumstances. So that was the answer. More than I've given you more answers than required. So if you look at this question 4, this question 4 was not very difficult. This deals to do with the offlands and easements. These are questions that have been asked in the past, of course, with necessary modification. So someone who could have read this could have passed. So this was not a completely new question. So connected to this easement topic, there are these called analogous rights. So analogous rights, if you look at the easement and analogous rights has not been tested. Right of way, access order. So these are an area someone's need to look at. Public right of way, communal right of way, where lives. Yeah, all the way. So that's why I'm telling you it's very, very important to you read and understand the Land Act. So that one can come. Analogous rights has not been tested anywhere in the past. Section from 138 going down until section 149. So we are together.
Yes.
You are together, Kate?
Yes, Mwalimu. Yes, Mwalimu.
So I am go and look at that area. I don't want you to be caught unawares.
Yes, Mwalimu.
So let's go to the next question. You have been instructed by Eastern. We are going to look at the course outline after this. Some of the areas that have been tested are not been tested. So we look at so that because we see which area you need to work on. So question 5, you have been instructed by Eastern Finance, your client, to provide legal services in respect to the following matter. Peter approached your client for the financial accommodation in tune of 2 million that was secured over registration of a charge on title known as. Your client issued a letter of offer to Peter, which Peter signed his part therein, and he was required to deposit the title of property pending registration of duly executed instrument of charge in order to access the funds. Peter deposited the title and duly executed the instrument of charge. Your client has since learned that Peter has passed on and the instrument of charge are yet to be registered. So, Helen, how do you interpret this question?
The process of creating a charge had begun. Completion documents were exchanged. The secured amount was exchanged also, but the problem is that the charger died. So in this case, there is uncertainty on how that money will be recovered. Since it has not been put to use, then it is important that it be recovered. Yes.
Good interpretation. Every time you are you have interpreted well.
Yes.
So
yes.
until that time, so this question is reading you to, of course, he duly executed the instrument of charge in order to access the fund. He deposited the title deed with this Eastern Finance Limited. So, and the instrument of charge are not yet to be registered. You have not finished to interpret the question. So this question is reading you to where, Kate?
So there's several. So there are two bits that would need to be considered. Peter has passed away, so you will need to think about how then you do that process. So it falls within, I think, the process of transmission, and then how then you're able to place in the charge. So those are the things that come to mind. Of course, depending as to whether you're answering A, B, or C,
Let's be
it will
specific.
determine.
Answer A.
Yes.
Yeah. Answer A. Explain the nature of interest that your client may have in respect to the said property. So what is the interest?
So I would say, so first, I think we have two types of interest that one can have on property, the legal interest and the beneficial interest. In this regard, the client would be having legal interest because the property was supposed to be charged and his interests are noted on the title. So I would call it legal interest.
Helen? Give it a try.
I think the answer she said is similar to what I was thinking.
So this question is testing you on informal charges. So you must know the difference between formal charge and informal charge. So a formal charge is when it is registered in the land registry. That's when it comes
But
from.
Mwalimu, the intention for this was that it would be formal. And that's
Yes.
why it asks for all these documents. When it's in the process, do we look at the intention or do we look at how far it's at?
It is the intention, but it has not been registered. So I don't want you to, I want us to read the Land Act. If you read that the Land Act is going to answer you on your question. I want you to answer you. The process had started. They had the intention, but until you reach the registration and the charge is registered on the registry and it is noted on the register that this charge is not is nini, that this property is charged, that is a form of charge. But if the process had started and it has not, the documents have not been taken in the registry, that is an informal charge. Are we together? So you look at Peter deposited the title and duly executed the instrument of charge. Your account assist land that Peter has passed on, and the instrument of charge are yet to be registered. So that is where the crux of the matter is. So I want to project the Land Act again. So this is topic on charges. Topic on charges. It start at I think section 79 going down. So section 78 going down. General provision on charges, where it talks about informal charges, formal charges, of a charge, right to discharge, transfer of charge, which chargee consent, covenants, condition implied. So all these things, right of the chargee to sell a property. So informal charge. So what is an informal charge? Section 79(6). An informal charge may be created where? Okay, what is a formal charge? Section 76, 79(5). A formal charge shall take effect only when it is registered in the land register, and a chargee shall not be entitled to exercise any of the remedies under that charge unless it is so registered. So are we together, Kate, there?
Yes, Mwalimu.
So a formal charge shall take effect only when it is registered. So anything that is not registered and you had started the process is as an informal charge. So an informal charge may be created where a chargee accepts a written witness undertaking from the charger, the clear intention which is to charge the chargee's land or interest in land with repayment of money and money towards obtained from the chargee, while interest agreed on the charger and chargee. So a chargee accepts a written and witnessed undertaking. The chargee deposit any of the following: certificate of title of the land, a document of lease, any other document. A chargee holding an informal charge may only take possession or sell land which is subject to an informal charge on obtaining an order to the court to that effect. And if that is now section 75(8). An arrangement contemplated in section 6A may be referred as informal charge, and a deposit of documents contemplated in 6B shall be known as a lien by deposit of documents. A charger shall not possess or sell land whose title document be disputed by a chargee. A charger shall not possess or sell land whose title document has been deposited by chargee and an informal charge without a court order. So a chargee cannot sell without a court order, and a charger cannot cannot possess or sell land when there is an informal charge. So when you read section 75, 79, it answers the question that this is an informal charge. Because here we are told, your client issued a letter of offer to Peter. Peter signed his part and deposited the title to the property pending registration, but registration was not done. So you need to discuss about informal charge and what it means, and what I have, and you quote section 79(6). Are we together?
Yes.
And
Yes,
you earn
Mwalimu.
yes, and you earn your 2 marks. So explain the
So in
immediate
this
step.
case,
Yes.
in this case, you would be saying that the nature of interest is a charge, and in this case, this is an informal charge because it is not registered. So that becomes 2 parts in terms of you saying, yes, it's a charge, but then provide the type of the charge, which is an unregistered charge.
You use the language used under the Land Act. you
Mhm.
go direct. It is an informal charge. You don't need
Okay.
to say it's unregistered, it's a charge which is not, it's an informal charge.
Okay.
It's an informal charge which is where, because the chargee accepted, gave the offer letter to this person, he signed it, then he deposited the title deed, but the charge has not yet been registered in the registry. Unaona? That is your
Understood.
explanation, eh?
Yes.
And you earn your 2 marks. So explain the immediate steps that your client must take in order to be able to claim the advanced amount. So explain the immediate step that your client must take in order to be able to claim advanced amount.
So when I looked at this and I looked at the fact that now that Peter is deceased, I think I would say the first action is to notify the representative, the estate representatives, or to notify the estate. That's one, but also the another step that would be necessary is to make registration of the charge, but none of those two steps get them to claim the advanced amount, and that's where I got stuck. Because then he'd have to claim it from the estate. Yeah.
So, yeah, that is a good trial. Helen, you can try.
I was also thinking about the registration of the charge. I don't know whether it is possible. I was thinking about registration of the charge. Also, for this person to be able to claim, there's something something about where there's a summons for confirmation of grant. Once the grant is confirmed, there's usually an affidavit that is sworn, where there's a list of assets, liabilities, debts, and it means there has to be communication with the administrators. Whoever has been given the grant, whether it's probate or letters of administration, there has to be some sort of communication so that when they are listing debts, you'll be one of the people there. So there has to be some form of communication. I know they have to go through court, but I was thinking of that.
Yes. So, your answer, Kate, is more. You remember I told you in every given question, in an exam, you must tailor your answer to what. Of course, after reading the Land Act and land registration, having the knowledge, you must be able to apply it to the question. Application becomes very difficult for students, even if you have been able to you understand your Land Act, land registration, and subsidiary registration. So the crux of this question is claim the advanced amount. Remember, he was given 2 million, and he has died. So that money, 2 million, could be either in the bank, he could have used and or it could have been, it could be in the bank, you could have used it, but there is this the property. So now how do you realize the advanced amount? So you go back to where you have read. You go back to where we have read. So section 138, 79.7 is relevant. So a chargee holding an informal charge may only take possession of or sell land which is subject to an informal charge, or obtaining an order to quote to that effect. So the answer was the bank. What are they called? That is the answer. The East Finance Limited needs to go to court under section 79.7. And be able to realize to be able to realize their either take possession or sell property. Of course, before that, they need to talk to the personal representatives of Peter, because if you are going to court, you cannot sue a deceased person. And a dispute between to realize a dispute between a charger and chargee is usually originating summons. So the question you answer by first saying that they need to notify the personal representative and encourage them to take a grant ad litem. Remember, in your probate, a grant ad litem is used to sue or be sued. Of course, they are going to tell them that this Peter had their 2 million, and he needs to pay. From there, they can, if he had not used the money, it can be returned to this instant finance. But if they are not willing to return the money, or they have used, now they take possession or sell the property under section 79.7. So are we together?
Yes.
Yes.
Any question? You have said many things. So you say it in a structured way. The next question: discuss the critical steps that your client must take in order to realize the security, if any, in the property. So the keyword there at 4B, 5B was be able to claim the advanced amount. The keyword here is realize the security. So realize the security. Kate, you can try.
Maybe I'll try and maybe get a clarification on the extent of B to clarify. So here, in order to be able to claim the advanced amount, if I was to take with the approach that you'd use, perhaps because he appeared to have passed away very soon after getting the advance, is to write to the personal representative to get any amount that may have been unspent. Then if that's the case, part C, discuss the critical steps that your client must take in order to realize the security, if any, in the property. So this is where now it moves to the next step of getting a court order, going to court, going to court under originating summons and applying that you take possession of the land. And when you say realize the security, it could be either to have to register your interest and or based on section 79, subsection 7, sell and apply the proceeds of the sale to the repayment of the loan. Yes, so that's how I would approach part C.
Helen?
Okay, the answer that I was thinking of is it's the same one I just talked about going to court, hiyo ya kwenda court and informing the administrators so that when the time comes for listing, when they're listing assets, liabilities, and they're listing the debts, will be one of the people. Since if the money is already, of course, in the hands of the deceased somewhere. So if you make that application, you'll be listed among the debtors. Then during your debt, the money secured will be paid from the estate of the deceased. That was what I was thinking.
So when I was looking at this question, I got confused. So able to claim the advanced amount, that is B, and realize the security. What is the difference? Because you see, you cannot put the answer for B to C. Kate, what do you think?
Yeah, I totally agree, which is why I started in answering C. I started by splitting the answers, whereby part B, because it's to claim the advanced amount is different from realize the security. So here, the application, the claim
what is
to the
mean?
personal representative would be part B, and then anything to do with now getting a court order relating to the property is what I would put as part C. So I would use section 79, subsection 7 to answer part C. But part B, I would say to write a letter to the personal representative making a claim. Yeah.
Yeah. So you must, that is correct. And of course, when you are talking about yeah, so you must be able to differentiate the two and bring out your, you know, you must bring out the differentiation. You cannot, in an every given exam, you cannot put the answer for B to C. Yeah. So there is a case law here. Jamii Bora Bank.
Mwalimu, we can't see what you're reading. We are only seeing the act.
Oh, okay. So, yeah, there's a case here. There is a case here called Jamii Bora Bank versus Sospita Getonga Giro, 2018. it is a very good case. I think I can project, because in an exam, every time you are talking about a court, you are talking about going to court. It's always good to talk to give a case law. Yeah, so let me project a case law here. Yeah, so yeah, so this case, you can see it, eh?
Yes.
So these are very good case law to talk about when you are talking about where the chargee went to realize a security because of an informal charge. You can quote this case law. Even in civil litigation, by the way, it can come. You can be given the same scenario in civil litigation. Jamii Bora Limited versus Peter Getonga 2018. So the applicant, the charger, Ian filed originated seeking leave to dispose the property known as red reference. So grounds on the face of the vacation, the applicant advanced financial facility to the respondent, Jamii Bora. So here is the chargee, not charger. The applicant, the chargee. Yeah, through an originating summons. The respondent had refused. So the chargee was holding the title and is the serious of recovering a standing amount by calling the security by the chargee. So remember, he must go to court so that to be able to sell the property. And it was given. The applicant is hereby granted leave to exercise its power of sale under RRA number through the process provided under the law. So this is a very good case. Miscellaneous civil suit number 497 of 2017. Are we together?
Yes, Mwalimu.
Yes. So this is a very good case. It can come also in civil litigation. So let's look at our final question of the day. Chargee and chargee is a very common topic in exams. Yeah, informal charge. So these are very common question. So let's look at the final question of the day. Farida purchased a parcel of land at Billy Shopping Center in the year 2011 through an allotment letter. Number NOC Trading Center 119. Let me project. Farida purchased a parcel of land on Billy Shopping Center in the year 2011 through an allotment letter number NOC Trading Center 190. She unfortunately met her death 10 years later after only managing to pour construction materials. So he died in 2021. Amelia, her daughter, does not wish to pursue the project or retain the property. She has found a buyer, Mwajuma. So the buyer is called Mwajuma. That's how you interpret. Wishes to seek financial to settle the agreed purchase price. So Mwajuma wants to get money to be able to buy this property being sold by the daughter. In the circumstances, the two individuals approached your office seeking legal guidance. So they have come to your office. The daughter, whose her mother bought this land, and it was a letter of allotment, and the buyer, the intended buyer. The two individuals approach your offices seeking legal guidance on procedure to be followed in authenticating ownership and enablement of Emilia to sell the said piece of land. So I have interpreted the question for you. So this question 6A has two parts. Procedure to be followed in authenticating ownership and enablement of Ameria to sell the said parts of land. So when you're answering in an exam, you must be very specific. You must ask by saying the procedure to be followed by Amelia in undertaking the ownership, then the enablement of Amelia to sell the piece of land. So you can give 2 points in part one and maybe 3 points in part B, the other part of A, and you get your 5 marks. So, Kate, what do you think?
So I had tried to research this question. So I'll make an attempt. So first, when a letter of allotment is issued, it does come with conditions. So from the story given, it is not clear as to whether Farida did write an acceptance of offer to the National Land Commission. So that's the first step that to ensure that one does that and then commit to fulfill the conditions set out in the letter of allotment. Then the next step would be that Farida's daughter, Amelia, now makes the relevant statutory payment for the survey of the property, the marking of the various boundaries using a licensed surveyor. Now, from the report of that survey, they would then get the report of that survey. Then they could, so Amelia can, so that's the first step for authentication of ownership. So the step of response of the letter confirmation, statutory payment, you have the license surveyor to come check the number and the size of the plot and number it. Then for the answering of the question of enablement of Amelia to sell the said piece of land, is that Amelia cannot sell it while it's still in the allotment format. And it needs to have, she will need to have gone now beyond now the survey of information to now request the National Land Commission to prepare the lease documents. And so that's, so it would need to be under lease, a lease document for it to be ready to sell. Because at that point, once the preparation has been made, then the Ministry of Land or the registrar now makes confirmation of the survey information that had been done previously by the surveyor. So I think I'm getting into part B, so I think I'll stop there. But so that's the first part in my view. Yeah.
So, good trial. Helen, what do you think?
My answer is also similar to hers, because the first part has to do with the version of the allotment letter to a title. Because she needs to pass a good title. She has explained the process better than I would have, but the first part has to do with the conversion of the allotment letter to a title. Then the second one will have, the second process will have to do with, for her to be able to sell the piece of land, it means that the title has to be registered, of course, and whoever is trying to buy the land has to conduct a search to confirm ownership. After confirming the ownership, then that is when the sale agreements are drafted and signed by both parties, where the transfers are drafted and signed, and also registered. Then stamp duty is paid, and when completion comes, the documents, of course, the title is now handed over. Well, the balance of the deposit was already paid, and the balance is now exchanged at the point of exchanging the completion documents. That is what I think.
So
Okay.
maybe something else that I may have missed and perhaps guide in terms of it being conveyancing, like how much detail would do we need to go into? So the mother died. So it means that now this property is now sort of, again, it reads like it's more intestate. It's not clear whether Amelia is the only child of Farida.
Yes, it is.
So
You see,
uh-huh,
in an exam,
uh-huh.
you don't you deal with what you have been told.
Okay.
You cannot
So,
start guessing. Is the only child
so
according to
would
the
you,
question.
so would you now in this case indicate that Amelia would need to follow the relevant process of administration and
Yes.
acquire the grant? Now, once that has been done,
so there's something you are missing. You see, anytime. In fact, this I forgot to tell you when we are doing yesterday. In an exam scenario, there are three interests in a land. There is freehold, leasehold, community land, and of course private land, public land, and community land. And in private land, there is freehold and leasehold. So every time you are dealing with anything to do with land, first of all, in every exam, you must ask yourself, is this private land? If it is private land, is it freehold or leasehold? Unaona? So leasehold, they usually talk about peppercorn, paying rent, and all those. So you know it's a leasehold. So, and the leasehold most of the time is the land that is in the municipality, in towns. Then freehold most of the time is in villages. Then there is public land. And public land, they usually mention the National Land Commission, and community land is expressed. As we talked, look at question 1 there. They were talking, when you see there, this land is held by a community, nini, nini. So, first of all, is to establish what kind of land is this. So, letter of allotment that we are talking about is where a national, when you talk about National Land Commission, always, it is where is conversion of public land to private land. But here there is nothing to do with this. Is not conversion. This is purely private land. Are you together to this to that far?
It is not clear because this is a letter, there's an allotment letter, and
Yes.
allotment letter is given when public land is being converted into private mostly, and that is handled by the National Land Commission.
Yes, then
yes.
Yeah, that is one. A letter of allotment are also given by private companies. When someone buys,
but with the setting up of the National Land Commission, wasn't that relegated to the National Land Commission?
You see, in your practice,
Uh-huh.
in you can Google or ask someone after this. There are companies which usually give letter of allotment to their shares. You remember this called what are they called? Kasi ranching, ranch. You know a Bakasi ranch,
I've heard of it, but it's familiar.
So a Bakasi ranching, you can go even right now when you are talking. A Bakasi ranching was giving letter of allotment to their members, shareholders, and it is just the other day people were being given the title deeds, which is purely private land. So this is what the question is asking you about. This is a letter of allotment given by a private company on a private land. This National Land Commission does not have anything to do with this land, with this question. Let's me project a question that involved the National Land Commission. Kate, you see the difference?
Okay.
Yeah, I want you to get the difference. I want to project to you where a letter of allotment was a question was asked. Okay? I want to project November 2023. I want you to get the difference. Where a question of letter of allotment is used in where in private land and public land. So I want to go to my past papers, conveyancing past papers, November 2023. So this was question 1. And you remember yesterday when we were talking about something to do with the private, I was telling you this question can be asked in where it is concerning public land or community land. So that is, you must know the how someone holds land. So if you read this question, I want you to see the different where letter of allotment is there in public. That is conversion of public land to private land, and this is where you talk about the National Land Commission. So you can see the projection.
Yes, we can.
My study is a prominent business with interest in transport, logistics, real estate, hospitality, and entertainment sectors in the north coast of Kenya. His appetite for real estate has been soaring owing to the attractive returns on investment. He has been scouting for parcels of land to set up hotels to the position himself as a share of profit, abundant land and international tourists flocking the coastal region of Kenya after vanquishing of COVID-19 pandemic. He's immensely elated after finding a prime price of land situated next to Fort Jesus, Mombasa. Upon conducting a site visit, Machandari has noted the parcel of land faces Indian present one of the magnificent vista of the passive Indian Ocean and captured with elegant views of the English port marina on the other side of the ocean. Machandari has come to learn that Nasi is the owner of the parcel of land measuring 1/4. Nasi had agreed to sell and Machir has agreed to buy the land at 250,000 shillings. Nasir had disclosed to Macharia that he was allocated this land. The previous order was allocated this land by the late President Moi in 1998 and subsequently applied for and was issued with both letter of allotment and certificate of lease of Mombasa block by the then Commissioner of Land. So from reading of this question, from Nasir was, he want to sell it to this person by Zandaria, but he applied. He was issued by late President Moi in 1998 as a secretary applied for and issued both allotment and certificate of lease by the then Commissioner of Land. Of course, 1998, the National Land Commission was not there, and this public land was being issued by the then president. So, having regard to the recent Supreme Court jurisprudence that a title of lease is the end product, advice must share on the appointed you as his advocate. How will you go beyond the usual official search at the registry to protect his interest? So this question is talking about allotment of land, allotment of letter and certificate of lease issued by the then Commissioner of Land. So the question is very express. So every time you see that the question is talking about allotment of letter issued by the Commissioner of Land or National Land Commission after the 2010 Constitution, you know that it was public land and converted to private land. Are we together?
Yes.
So the question must be very express. It must talk about National Land Commission. I want to show you another question so that you know the difference.
So maybe before we move there, in my view, these two questions are different.
Yes.
For this particular one, it has gone all the way, and there's a certificate of lease that has been issued. So in answering that particular question is that the going above and beyond is to check whether this land appears in the Ndongo report, right?
Yes.
And
very good.
So
yes.
So that's, but it's different from how it is the previous one of getting to find out whether whether an allotment is private or not. But I seek your guidance, but that's my assessment.
So if you look at I want to show you another question that is talking about still allotment.
Okay.
Let's look at March 2023. March 2023 is also an allotment. I want to project. If you see a question being repeated that way, March 2023, November 2023, April 2024, is in quick succession. You know the explanation is? The explanation is student has not grasped this area. Yeah, even they said when they said that, I think when they went to talk to you just the other day. Any question you see being repeated this way, the student failed in this question. And it has been repeated. So letter of allotment will also be repeated in November 2024 again. Because it's a very difficult area. So now I'm projecting to you question 6 March 2023. In 2011, the government of Kenya designated 100. You can see,
Yes.
In 2021, the government of Kenya designated 100 acres of land in Kajiado as public land available for allotment to private parties. The government surveyor working together with director of planning physical planning prepared a scheme plan delineating land into 80-acre parcel of land. Following the due process, Andrew Silva applied and was allotted 1 acre of land known as, following which was issued a conditional letter of allotment. On receipt of the conditional letter of allotment, Andrew Silva announced to his family that they are now owners of 1 acre of land in Kajiado and that they would build a family home in coming 2 years. He then locked up a previous letter of allotment in a safe. In May 2015, Andrew Silva visited the parcel of land and was surprised to find construction of works going on. Furious and confused, he sought to know the trespasser, who was the trespasser was. The project foreman informed him that as far as he was aware, the land belonged to John Mukora, who was in process of building 4 houses for sale. Shocked at the news, Andrew Silva pronounced loudly that they would report the matter to his lawyer, and the lawyer would deal with whoever Mukora was. So, of course, we are not answering this question. I have answered them. But now here, you see, the question is very express. The government of Kenya designated 100 of acres of land in Kajiado as public land, available for allotment to private parties. So this is government of Kenya, public land. If you see government of Kenya, public land, letter of allotment, National Land Commission, you know now that is conversion of public land to private land. Are we together?
Yes.
But where the question has not talked about anything to do with government of Kenya, National Land Commission, public land, and there is letter of allotment, like this question 6, which I want now to project. Our current question 6. You now know that this is letter of allotment given by private companies to individuals, to their shareholders. And I have given you an example is Bakazi ranching. They gave the letter of allotment. They actualize. Yeah. So you must know that difference, eh?
So how would you answer this question then?
So this is how you answer the question, eh? Procedure to be followed in authenticating ownership. So remember, there is this company. So first of all, the first step, this lady is called, that was left, Amelia. Will you first ensure that you look at the allotment letter. Allotment letter has a description of the property, allottee names, and the terms of the allotment, and is usually issued like a share certificate. Eh? I don't know if I can see a sample letter of allotment online. Eh? You can go even you. They are very common. Eh? They are issued. So, but this is by a private company. Don't confuse by the same that I've told you about the government. So that is the first step. Second step, of course, you visit the company. Which issued the letter of allotment. Eh? And of course, inspect the register or inform to tell them if their mother Farida is still one of the registered shareholders. Yeah. So that is, you can say that in procedure for following authenticating, you must know that if this letter of allotment is still genuine. So answering the enablement of Ameria to sell the said piece of land. Now you say that a letter of allotment does not confer ownership. And you quote the famous Supreme Court case, Torino. Is it Torino? You know it, eh?
Hello?
Enter in purple valid title to the.
Hello, Mwalimu. We are losing you.
So you can hear me, eh?
Yes, now.
Yeah, I had gone offline, sorry. So I'm saying I was on enablement of Mameria to sell the piece of land. So you say a letter of allotment cannot transfer a nini, a title, nini. You can even quote section 26 of the Land Registration Act, which says that a title deed is the one which confer ownership. Certificate of title is the conclusive evidence of proprietorship. Section 26. So a letter of allotment does not confer any ownership, and a person cannot transfer an interest in land. That was a famous case of Torino Enterprises Limited versus Attorney General, Supreme Court. Then you also say that because this letter of allotment is in mother's name, and he has died, he need to get a grant to sue to get to petition court letters of administration, so that that bill can pass, the title can pass to her. Nini. Yeah. Are we together?
Yes, Mwalimu.
So that was the answer. So we go to the next question. In the meantime, Mwajuma has approached the bank loan approval to cover the balance of the purchase price. However, the bank has declined on the premise that he must first transfer it to himself, then convert it to the certificate of lease, or get a title against whose register a charge can be registered. Explain, Mwajuma, the procedure to be followed in converting the letter of allotment to a certificate of lease. So Helen interpreted that question.
Okay, my answer is just like the last part of the question, where what is required is the procedure for the conversion of a letter of allotment to a lease. You can see that that is what is required. She needs to get a loan. She needs to get a loan, but first of all, she needs to have good title or a lease as the bank requires. So as long as there's good title, then the bank can be assured that she has ownership, that she's the true owner of the land, so that she may be able to have the secured amount extended to her.
Kate, make a trial.
So I would say that the process, explain to Mwajuma the procedure to be followed in converting the letter of allotment to a certificate of lease. So
Remember,
the first, yes.
Remember, this property is still in the name of Farida.
Yes.
Yes. So you come from that area, from that understanding.
From that point.
Yes, it's in the name.
Yes.
And yes.
So the first step is to check whether Farida had met the conditions of the allotment. And that should be denoted in an acceptance letter indicating the acceptance of the allotment and how the conditions have been met or how the conditions will be met. Then once that confirmation has been done, then a licensed surveyor shall be engaged. So there's another, the other bit of information you had indicated that where allotment now, we're assuming this is private, that then we trace the, like the genesis of why Farida got the allotment is perhaps that she had shares in the company. So all that verification is made to ensure that Amelia now is linked to be the one who now has rights to transfer that to Mwajuma. So once that has been done, or that pre-verification, then they engage a surveyor, a licensed surveyor, who will now map out the areas and then map out the actual section of the property. It's the mandate of the registrar, or it is the role of the registrar to issue titles, right, or certificates of lease. So an application will need to be made to the land registry for that area, seeking to apply for a certificate of lease. And that will be done by now attaching the relevant documents. And in this case, because it is private, it's private owned property, there might be a requirement to, as part of the documentation, to have the mother title attached. That and the survey report. Then the land registrar would now make verification of those surveys, the numbering, and I think, I'm not very sure, but I would imagine working the process to insert now this new information in the cadastral map, because it is from that map that titles are issued. So the process of updating the cadastral map to now include the details and the number of that property will be done. And then they would start the process of issuing the certificate of lease. So once the certificate of lease has been issued, then Mwajuma can do a search of that, or Amelia can do the search to confirm that now the registration is there. Of course, by that time, they'll have been issued the certificates. Now, now to get it to the next step of that it needs to be in his name first, then becomes the issue of the sale agreement between Amelia and Mwajuma that now agrees on the process of when completion documents will be done for the release of or for the change of names and then subsequent registration of charge. That's yeah, but I'm sort of grasping based on previous information.
Yeah, that is correct, very correct. You have even given more than what is required.
Okay.
So, the question was very direct. Explain, Majuma, the procedure to be followed in converting letter of allotment to certificate of release. So, you said 5 steps, like what you have talked. Of course, number 1 is to see that he had going to the company and see that they had a mother had met the nini, the conditions of the allotment. Unaona? So that is the first step. Then survey and subdivision, as we have talked. Of course, there may be a sale agreement between the company and her. And then issuance of the title deed. Yeah. So if you arrange those in points form, you get your 5 marks. Yeah. So this every time you remember, letter of allotment applies to both private land and public land. That is the secret, the catch.
Yes.
That is the catch. Letter of allotment applies to private or public land. And private land, when you see they are talking about Government of Kenya, National Land Commission, public land, you know that is the conversion of public land to private land. Now you talk about National Land Commission, but this is silent. So this is private land. So we have come to the end of the our question. This was not a very easy paper, but someone who has read good the Land Act and Land Registration and look at the past papers could still have passed. So I want to project the course outline. Because now we are coming to an end of this subject. I want to give you some guidance. Course outlines 2024-2025 conveyancing. So in light of the fact that there are many, if you look at April 2024, there were very many new questions which are not been tested in the past. So I want you to look at these areas. These areas have not been tested. I told you yesterday
sorry, which areas
have not been tested. Yesterday, you can see the course outline.
Yes.
Procedures of converting categories of land. I told you the 3 categories which have not been tested.
Yes.
Yeah, I know you wrote. I don't need to repeat. (2.8) customary land and overriding interest. That area has not been tested. Never. Look at that. So if you see a question, we talked about overriding interest. I don't need to repeat on section 28 of the Land Legislation Act. Customary land, how do you identify customary land question? You will be told that this was an ancestral land. The father died, the title was in the firstborn son, but he was holding in trust for the other brothers and sisters, and he sold. Was that valid? The sale was valid. So it is talking about these customary land rights. Are we together?
Yes.
Yes.
So write that, note that one. Pre-contract stage week 4, everything here have been tested. Maybe they are going to repeat. Power of attorney is not difficult. Professionals, due diligence, investigation of title, acquisition, that is easy. Contract stage. Law Society Condition of Sales, 2015. Read and understand it. I think I had said that before you joined.
Okay.
Any sale agreement that you see, any kind of sale, by default, it applies. The Law Society Condition of Sale 2015 applies, and that it is excluded. So you need to read and understand it. An exam scenario is that they are going to give you a sale agreement. The purchaser did this, the vendor did this. What will happen in a sale agreement? What is the scenario? For example, what happened? For example, if the purchaser takes possession before completion, or what is another thing? For example, if completion does not happen on the due date or such kind of thing, read and understand the land, the Law Society of Kenya Condition of Sale 2015. So in a sale agreement, they're going to ask you, it is your knowledge on Law Society of Kenya Condition of Sales 2015. They want you to apply. Are we together?
Yes.
Yes.
Professional undertaking, that's a common question that come even drafting it. Role of lawyers, vendors, advocates, purchasers, that's not a difficult area. Now, comparing conventional agreement for sale and other that caters for other scenarios. Sale and purchase through auction. These are questions that has come many times. So you need to know sale and purchase.
Which one?
Sale and purchase through auction, 5.1.
Okay.
You need to know how it applies. Sale of property off plan, we have dealt with it. Sale of a sublease. This one has not been tested. This one can come. Sale of property through survey or subdivision sales. This one has come. Sale and purchase of leased building. This one has not come. Sale and purchase of leased building, 5.5. So that one has not come. Look at that. Sale and purchase of community land. This is where we talked about conversion of course, it's conversion of community land to private land, or conversion of community land to public land. Yeah, so that is sale and purchase of community land, because the government can buy a community land or a private person. Look at that. Fractional sale and timeshare, it has come. Sale and purchase of property through a cooperative, that has not come. So you need to know the process. 5.8. But through a land buying company, this one has come, where the land buying company must go and their shareholders pass a resolution. Then, of course, the officials do the signing. It has come. But sale and purchase of property through a cooperative has not come. You know, CLE usually asks the question from the course outline. You remember they told you that, Kate?
Yes.
Whether you have learned in class or not, it does not matter. Transfer 6.1. Transfer has come, transfers of land by consideration of not or not. Even they have asked how to draft a transfer of land. Transfer form, Now, an area that has not been tested, 6.2. Transfer of freehold, transfer of leasehold, transfer of charge, assignment, transfer of profit, transfer of undivided share. This is an area that, apart from transfer of charge, maybe all these areas, this area has not been tested, except transfer of charge. So go and polish on that. Section of,
Okay.
yeah, that one has not been tested.
Yes, 6.2.
6.2. Sectional property and subleases. Sectional property question usually come, and of course it can come as a repeated question. Sublease, it has been tested. Completion document, very common question. Transmission, what is called involuntary transfer. We dealt with the death of the proprietor, common
Yes.
question. Now, what has not been tested here? Compulsory acquisition, many times. So what has not been tested well in this area is court attachment and sale. You are now apply your civil procedure. Vesting orders, insolvency, adverse possession. This an adverse possession is only in civil litigation, not in conveyancing.
Okay.
Matrimonial property, where, for example, someone, the wife, non-contribution, all these things, is told to own a property because of non-contribution upon divorce and all those things. So this area, except death and compulsory acquisition, polish up all the other areas.
Okay.
Tenancies and licenses. These are an area that have been tested. It can be repeated. There are many question and answers. Landlord and tenant, they have been tested. Remedies and relief for lessor and lessee, tested many times. Charges. So today we have dealt with formal and informal charges. Equitable and legal, father and second, third and third party charges. Priority of charges, stacking and consolidation. So you read Land Act, all those sections. Basic requirement of a charge. Duty and responsibility of advocates, covenants in charge and import thereof. So the area that has not been tested most, of course, is formal and informal charge, which has okay, informal charge, we have dealt with that. Equitable and legal, not much. Third party charges, go and polish that. Priority of charges and tacking of and consolidation, polish on that. This has not been tested.
Mm-hmm.
You can be told to draft a charge. Go and do it. Remedies of parties, these have been tested, of course, of the chargee many times. Sale of the charge property, yeah. So, right in Alen Solo, we are at topic 5. So, easement and analogous rights. So, we have talked about easement.
Yes.
So, this area you go and polish everything here. This is an area that has not been tested much.
Mm-hmm.
Entry orders, what are entry orders? How are they gotten? Access orders, what are they gotten? The difference between express grant, implied easement, and express reservation, cancellation and extinguishment of easement, profits upon the restrictive covenants, creation and cancellation of easement, profit restrictive agreement, way leaves. This is an area that has not been tested much. So polish on that. Caution, inhibition, and restriction that has been tested a lot. Taxation in conveyancing, stamp duty, and capital gain. You know how stamp duty is paid. Exemption to stamp duty, tested many times. Stamp duty 4% municipality. And by the way, municipality, there are so many areas now gazetted by the governors. Every governor is gazetting area to be so there are so many municipality areas, and you go online and check the latest municipalities to be able to answer. So 4% applies. Capital gain tax is 15%. Compulsory acquisition tested many times. Other method of acquisition of titles. So allocation not tested much. Okay, this is allocation for public land to private land that has been tested. Prescription, not tested much. Settlement programs, not tested. Where, for example, what are they called? These people, IDPs.
Yes.
Are settled by government, settlement programs, and how the processes, everything. So this is an area that has not been tested. Change of user and extension of user tested many times. Of course, Physical Planning Act and its regulation applied. Extension and renewal of leases tested many times. Yeah. Institutional
So I have a question. So
yes.
when you say tested many times, you had said with regard to allotment, it has been tested because people fail a lot. So when you say something has been tested many times, is it because of that, or is the probability of it changing not being tested high? If you could please guide.
So a question is usually tested repeatedly. So you have seen that on allotment of letter, it came in March 2023, November 2023, April 2022, 2024, because student has not been has not captured the what's the letter of allotment. That question was failed. So they keep on repeating it again. But when a question I say is tested many times. For example, it can be tested because of that. But you see, a question, for example, what has said, process of compulsory acquisition. They can test you in different scenarios. For example, you are going to be told, I remember one question that Machakos County government, the National Land Commission, they want to expand roads, do what they want. So that is one scenario. No. So they want to get properties from the private people. Then they can also tell you that the county government want to expand its offices. So it is different scenarios, but applying the same principle. Unaona? So, for example, when I say about cautions, you remember the question we dealt with cautions yesterday?
Yes.
That was a person who had purchased a property, but it was never transferred to him. That question applies. Another question, we will see them saying that for example, a wife contributed to buying of a property to the husband. He gave him the money, but was not noted on the was not registered in the title deed. He has just realized that the husband is about to sell his property. So what do you do in that scenario to secure her interest? Register a caution. Register a caution, and also then go to court for declaration of matrimonial property rights. You remember where I've talked about this, the topic here we have talked, it's, you see, where we have talked about the matrimonial property. A question is repeated, applying many scenarios.
Yeah.
Different scenarios, and but same. But it can also be repeated because students are failing a lot. Unaona? So we have 2 minutes to come to the end of our class. Yeah, it's ending at 11. So I have guided you sufficiently.
Yes.
Yeah, I have guided you sufficiently. Even Nani logged out,
Helen.
Helen, it was good. So thank you very much for attending this class. And with that guidance I've given you, I can tell you, you are going to smile when you see the conveyancing paper.
I pray to God.
Yes. So thank you very much.
Yeah. So maybe before we end, Mwalimu, criminal litigation